The discovery phase of a lawsuit is where both sides get to learn about each other's case. There are two types of discovery: documentary discovery and examinations for discovery. In documentary discovery, each side will give their relevant documents to the other side to review. In examinations for discovery, both sides are allowed to ask questions of a representative of the other side to learn about their case. In this video, we're going to discuss examinations for discovery so that you can be more comfortable when you are being examined in your case. We will refer to examinations for discovery simply as discovery for short form. Well, although the discoveries are part of the court process, they don't take place in front of a judge and they don't take place in a courtroom. They take place outside of court, either at a court reporter's office or in a conference room in a law firm much like this one. Who will be present at the discovery? You will be present, your lawyer will be sitting beside you, and across the table will be the lawyer for the other side, as well as their client or a representative of a corporate defendant. There will also be a court reporter at the discovery. The court reporter's job is to make a transcript of everything that is said on the record. They will later produce that transcript for use at trial and for the parties to review in preparation. There's nothing improper about meeting with your lawyer before discovery to try to make sure that you are as prepared as possible for your examination. You might be asked a question about whether you met with your lawyer, and if you are, you should simply answer yes. You should review the pleadings in the lawsuit, and that includes the statement of claim, the statement of defense, the reply, if any. This will give you a good refresher on what the lawsuit is about and what are the arguments both sides have for each other. You will also want to review all of the documents that you produced to the other side in the lawsuit, as well as the documents that the other side has given to you in the course of the lawsuit. Try to review the documents in two phases. First, take a good look at everything in the case once, put it aside, and then a few days before the examination, review it all again to make sure that it's fresh in your mind. When reviewing the documents, try to ask yourself the question, what is important about this document? What question is likely to be asked about this document? Also anticipate further questions that may arise from the documents. For example, if your document is an email, you might be asked if there was a response to the email or a follow-up email, and start thinking about those types of questions. If you are being examined as a representative of a corporation, there's an additional obligation, and that is to find the documents that are in the possession of other people within the corporation, and to make sure that you are informed about the events from those other people who have relevant knowledge. Remember that in Ontario, a person is only allowed to examine one representative of a corporation, but that representative must be informed about all matters relevant to the case. Remember, you want to make a good impression on discovery. You want to make sure that you are a credible witness at trial if your evidence from discovery is read to the judge. Dress professionally and try to conduct yourself as if the judge were there. Your lawyer will tell you what documents you should bring with you to the discovery. You shouldn't bring any notes that you've made in preparing for discovery. However, when you're asked a question, if you believe that one of the documents in your productions would help you with that answer, you're perfectly entitled to say that and to ask if you can review that document. Remember, it's not a memory test. As the name suggests, discoveries are a way for one side to learn about the other side's case. Unlike what you might see on television, trials are not conducted by ambush in modern times. By the time you get to trial, both sides should know everything important about the other side. The way they learn that is through the discovery process. When it comes to trial, there really shouldn't be any surprises. One of the important things to remember is that a party cannot rely on its own discovery evidence at trial. Only the other side is entitled to read the transcript from the discovery to the judge. So what that means is discoveries can't really help you. They can really only hurt you. The best way to answer a discovery question is simply tell the truth in a direct and straightforward way. Don't engage in argument. Don't show emotion. This is not your day in court. This is an opportunity for the other side to learn about your case, to help their case, not yours. Your lawyer will be listening to the questions, and if the question is not a proper one, the lawyer will object and tell you not to answer the question. In that case, listen to your lawyer and don't answer the question. Sometimes the other lawyer will ask you a question that you don't understand or that's complicated, or maybe the question is broken down into too many parts. In that case, you should tell the questioning lawyer to repeat the question or to ask it in a simpler way. Sometimes the questioning lawyer will ask a question that you can't answer on the spot, but you might be able to answer after the examination is over by going and asking other people, for example, or going to look for documents. In that case, if it's appropriate, your lawyer will give what's known as an undertaking. An undertaking is a promise to provide an answer at a later date in writing. The answer to that undertaking forms part of the examination for discovery. But you should let your lawyer determine whether or not it is appropriate to give an undertaking and not volunteer to give that undertaking yourself. Once the examination has started, you cannot have a private conversation with your lawyer, either on the record or off the record, until the examination is complete. That means you can't whisper to your lawyer, you can't pass notes to your lawyer, and even during breaks, you can't ask your lawyer how the examination is going. Once the examination is complete, your lawyer will tell you how you did and will discuss what additional work needs to be done following the examination. If at any time during the examination you need to take a break, just ask the opposing counsel. If you realize after an examination that you gave incorrect or incomplete information, you should let your lawyer know. Your lawyer has the opportunity to submit corrected answers or additional information to make sure that the information you have provided on discovery is accurate. Thank you for watching Discovery Basics. In our next video in this series, we will conduct a short mock examination for discovery, so you will have a good idea of how your discovery might go.